If you're married to a U.S. citizen and waiting for your green card, or if you're planning to sponsor your spouse for immigration, what I'm about to tell you could completely change your timeline and strategy. The Trump administration has just announced new rules that could impact thousands of marriage-based green card applications. And if you don't understand these changes right now, your application could be delayed, denied, or put under intense scrutiny that you weren't expecting. This isn't about politics. This is about understanding the new reality of immigration law and protecting your family's future in America. Stay with me, because the next few minutes could save you months of delays and thousands of dollars in legal complications. Hello everyone, and welcome back to US Visa Info, your most reliable source for immigration news, visa updates, and green card information for the United States. My name is your host, and today we're covering a breaking development that's sending shockwaves through the immigration community. The Trump administration has implemented new policies and enhanced scrutiny measures specifically targeting marriage-based green card applications, and these changes are already affecting thousands of couples across America. Whether you're a U.S. citizen trying to bring your foreign spouse to America, a green card holder sponsoring your husband or wife, or someone already in the process of adjusting status through marriage, you need to understand exactly what's changing, why it's happening, and most importantly, what you need to do to protect your case. Let's dive straight into the details. Marriage to a U.S. citizen or lawful permanent resident has always been one of the most common pathways to obtaining a green card in the United States. Each year, hundreds of thousands of people receive green cards through marriage, and it's generally considered one of the more straightforward immigration processes because U.S. citizens have the right to sponsor their immediate relatives without numerical limitations or waiting periods beyond processing times. However, marriage-based immigration has also historically been subject to fraud concerns because some individuals have attempted to use sham marriages purely for immigration benefits. This concern about fraud is at the heart of the new policies being implemented by the Trump administration. The first major change involves significantly increased scrutiny of all marriage-based green card applications. Under the new guidelines issued by U.S. Citizenship and Immigration Services, adjudicating officers are being directed to look more carefully at the authenticity of marital relationships. This means that even couples in completely legitimate marriages should expect more invasive questioning, requests for additional evidence, and potentially longer processing times. What used to be a relatively predictable timeline of 12 to 18 months for many applicants could now stretch to 24 months or longer as cases undergo enhanced vetting procedures. The types of evidence that USCIS is now requiring have expanded substantially. Previously, couples would typically submit joint bank account statements, lease agreements showing cohabitation, photos together, and affidavit from friends and family attesting to the genuine nature of the relationship. While these are still required, the new guidelines push officers to dig deeper. They're looking for evidence spanning the entire duration of the relationship, not just recent documents. If you met your spouse overseas, USCIS wants to see proof of how you communicated during your courtship. They want to see travel records showing visits back and forth. They want detailed timelines of your relationship from first meeting through engagement to marriage. They want evidence that both families are aware of and supportive of the marriage. One particularly concerning aspect of the new rules involves the interview process. Previously, marriage-based green card interviews were conducted with both spouses present, and the officer would ask questions about the relationship, living situation, and plans for the future. Under the enhanced scrutiny protocols, USCIS officers now have expanded authority to separate couples during interviews and question them individually about intimate details of their relationship and daily life. The questions can be extremely personal, covering everything from sleeping arrangements to what each person ate for breakfast that morning to details about the other person's family members and employment. The goal is to catch inconsistencies that might suggest the marriage isn't genuine. For couples in real marriages, these separated interviews can still be nerve-wracking because people naturally remember details differently or might be caught off guard by unexpected questions. Another significant change involves home visits. While USCIS has always had the authority to conduct unannounced home visits to verify that couples actually live together, this practice was relatively rare and typically reserved for cases where fraud was suspected. Under the new policies, home visits are becoming much more common. Immigration officers may show up at your residence without warning to verify that both spouses actually live at the address listed on the application. They'll look for evidence that both people's belongings are present, that there are photos of the couple displayed, and that the home reflects a shared life rather than a staged living situation. If officers arrive and only one spouse is home, or if the residence doesn't show clear evidence of cohabitation, this can trigger additional scrutiny and requests for evidence. The Trump administration has also increased focus on age differences in marriages, cultural differences, and previous immigration violations. If there's a significant age gap between spouses, USCIS will scrutinize the relationship more carefully to ensure it's not a marriage of convenience. If the spouses come from very different cultural or socioeconomic backgrounds, officers may question how the relationship developed and whether it's truly based on genuine affection versus immigration benefits. If the foreign spouse has any previous immigration violations, such as overstaying a visa, working without authorization, or providing false information on any immigration application, their marriage-based green card application will face heightened scrutiny, even if the marriage itself is completely legitimate. One of the most impactful changes involves the conditional green card process. When a marriage is less than 2 years old at the time the green card is approved, the foreign spouse receives a conditional green card that's valid for only 2 years, rather than the standard 10-year green card. Before the conditional status expires, the couple must jointly file Form I-751 to remove the conditions and obtain a permanent green card. This requirement has existed for many years, but under the new Trump administration policies, the scrutiny applied to I-751 petitions has intensified dramatically. USCIS is denying more I-751 petitions and requiring in-person interviews much more frequently than in the past. Even couples who have been married for years and have children together are being called in for interviews and asked to prove their marriage is still genuine. The consequences of a denied I-751 petition are severe. If USCIS determines that the marriage was fraudulent or has ended in divorce without a waiver, the conditional resident is placed in removal proceedings and faces deportation. Even if the marriage was genuine but has ended in divorce, removing conditions becomes much more complicated and requires proving that the marriage was entered in good faith or showing extreme hardship. The number of I-751 denials has increased under the current administration, and many couples who thought they were past the difficult part of the process are finding themselves fighting to keep their status years after their initial green card approval. Let's talk about some specific scenarios that are particularly affected by these new rules. If you married your spouse shortly after they entered the United States on a tourist visa or visa waiver, your case will be scrutinized heavily. While it's not illegal to marry someone who entered on a tourist visa, USCIS will question whether the foreign spouse misrepresented their intentions when they applied for the tourist visa. If they entered the U.S. with the pre-existing intent to marry and remain, that could be considered visa fraud. The burden is on you to prove that the decision to marry happened spontaneously after entry, or that marriage was contemplated but not the primary purpose of the trip. If you met your spouse online or through a dating website or app, you'll need extensive evidence of your communications and relationship development. USCIS wants to see chat logs, emails, video call records, and proof of in-person meetings before the marriage. Many officers are skeptical of relationships that began online, particularly if the couple has spent little time together in person before getting married. If you traveled to your spouse's home country and married them very quickly, perhaps within days of meeting in person for the first time, you should expect substantial scrutiny. If either spouse has been married multiple times previously, this raises red flags for USCIS. They'll want to see divorce decrees from all previous marriages and evidence that those marriages were legitimate. If the foreign spouse was previously married to a U.S. citizen and received immigration benefits from that marriage, their new marriage-based application will undergo extreme scrutiny to ensure this isn't a pattern of using marriage for immigration purposes. For same-sex couples, while marriage equality is the law of the land and USCIS cannot discriminate based on sexual orientation, same-sex marriage-based applications still face all the same scrutiny as opposite-sex marriages, and some couples report feeling that their relationships face additional skepticism, particularly if one or both spouses come from countries where same-sex relationships are not accepted or are illegal. It's important for same-sex couples to be prepared to provide the same extensive evidence of a genuine relationship and to be ready for potentially invasive questioning. The new policies also affect green card holders who are sponsoring spouses. Previously, lawful permanent residents could sponsor their spouses, but there were numerical limitations that created waiting periods. Recent policy changes haven't eliminated these waiting periods, but the scrutiny applied to green card holder-sponsored cases has increased. USCIS wants to ensure that the lawful permanent resident obtained their own green card legitimately and isn't part of a chain migration scheme. If you received your green card through marriage and are now sponsoring a new spouse, expect intense scrutiny about the end of your previous marriage and the beginning of your new relationship. So what can you do to protect yourself and strengthen your marriage-based green card application under these new rules? First and foremost, document everything from the very beginning of your relationship. If you're just starting the process now, create a comprehensive timeline of your relationship, including dates of first contact, first meeting, engagement, and marriage. Keep copies of all communications, including emails, text messages, social media messages, and video call logs. Take photos throughout your relationship showing you together at different times and places, and make sure the photos are time-stamped. The more evidence you can provide showing the natural development of your relationship over time, the stronger your case will be. Establish and maintain commingled finances as soon as possible. Open joint bank accounts. Add each other as authorized users on credit cards and title property or vehicles in both names. Financial commingling is one of the strongest indicators of a genuine marriage in USCIS's eyes. Make sure you're both listed on your lease or mortgage, on utility bills, and on insurance policies. Every official document that shows you're building a life together strengthens your case. Integrate your lives socially and familiarly. Make sure both families are aware of and involved in your relationship. Attend family events together, celebrate holidays together, and have photos documenting these occasions. Get to know each other's friends and socialize as a couple. Obtain affidavit from friends and family who can attest to the genuine nature of your relationship. And make sure these affidavit are detailed, not just generic statements of support. If you have children together, this is very strong evidence of a bona fide marriage. Make sure you have birth certificates listing both parents, photos of your family together, and evidence of both parents' involvement in the children's lives. If you have children from previous relationships, show evidence that your spouse has accepted those children and is involved in their lives as a step-parent. Consider hiring an experienced immigration attorney to handle your case, especially if there are any complicating factors such as previous marriages, age differences, cultural differences, or prior immigration violations. While it's possible to handle marriage-based green card applications without an attorney, the increased scrutiny under the Trump administration makes professional guidance more valuable than ever. An experienced attorney knows what evidence USCIS is looking for, can help you prepare for interviews, and can respond effectively if your case encounters problems. Prepare thoroughly for your interview. You and your spouse should review your application together and make sure you both know all the information on every form. Practice answering common interview questions about how you met, your wedding, your daily routines, your home, and your future plans. Make sure your answers are consistent, but also natural. USCIS officers are trained to detect rehearsed responses that sound scripted. Be honest and straightforward in your answers. If you don't remember something, it's better to say you don't remember than to guess and potentially contradict your spouse. If USCIS issues a request for evidence or notice of intent to deny, take it extremely seriously and respond promptly with comprehensive evidence addressing every concern raised. Don't ignore these notices or assume the problem will resolve itself. An RF or no is USCIS giving you an opportunity to strengthen your case before they make a final decision. Work with an attorney to craft a thorough response that addresses all issues. Be prepared for long processing times. Under the current administration, average processing times for marriage-based green cards have increased substantially. What used to take 12 months might now take 20 months or longer. Plan accordingly and maintain your status throughout the process. If you're adjusting status from within the U.S., make sure you maintain legal status while your application is pending. If you're processing through consular processing abroad, be patient and keep your documentation current. Understand that even after you receive your conditional green card, you're not done. The I-751 petition to remove conditions is increasingly becoming as difficult as the initial application. Start preparing for your I-751 filing well before your 2-year anniversary of receiving your conditional green card. Continue documenting your marriage throughout the conditional period. Don't assume that because you've been married for 2 years, removing conditions will be automatic. Under current policies, many couples are being called for interviews even when their I-751 petitions appear straightforward. It's also important to understand what these changes mean from a broader perspective. The Trump administration's stated goal with these enhanced scrutiny measures is to combat immigration fraud and ensure that only genuinely married couples receive marriage-based green cards. From the administration's perspective, they're protecting the integrity of the immigration system and preventing abuse. However, critics argue that these policies create unnecessary hardship for legitimately married couples, invade privacy, and reflect an overall hostile approach to immigration that assumes guilt rather than innocence. Regardless of one's political views, the practical reality is that these policies are in effect right now and are impacting real families. Couples who thought they understood the immigration process are discovering that the rules have changed significantly. People who began their immigration journey years ago under one set of expectations are now facing a much more difficult path. The uncertainty and stress created by these changes cannot be overstated, and many couples are making difficult decisions about whether to continue pursuing immigration benefits or to consider alternative options. Some couples are choosing to delay filing their green card applications, hoping that future policy changes might make the process easier. However, this strategy carries risks because immigration status can change, visa overstays can occur, and relationships can be affected by long separations. Other couples are accelerating their applications, trying to get into the queue before policies potentially become even more restrictive. Some are even reconsidering whether the U.S. is where they want to build their lives together, exploring immigration options in other countries that might offer more straightforward family reunification processes. For couples where the foreign spouse is already in the U.S. on a different visa, such as a student visa or work visa, there's the question of when to adjust status. Adjusting too quickly after marriage can raise questions about intent, but waiting too long can create status gaps or complications. This timing question has become more complex under the current administration's policies and requires careful consideration of individual circumstances. It's worth noting that these policy changes aren't legislative changes requiring congressional approval. They're administrative policy shifts implemented by agencies within the executive branch, which means they could potentially be reversed or modified by a future administration. However, for couples dealing with these issues right now, future possibilities don't provide immediate relief. You have to navigate the system as it exists today. The emotional toll of this enhanced scrutiny shouldn't be minimized. Having your marriage questioned and investigated is inherently stressful, even when you've done nothing wrong. Being asked intimate questions about your relationship by government officers, having your home potentially visited without warning, and facing the possibility of denial and separation from your spouse creates anxiety and fear that affects your daily life and relationship. Many couples report feeling like criminals despite having followed all the rules simply because the process itself has become so adversarial. For couples considering marriage where one partner is a foreign national, it's crucial to understand these realities before getting married. While you should never base a decision about marriage purely on immigration concerns, you should enter the process with clear eyes about the challenges you'll face. Make sure you're prepared for the scrutiny, the expense, the time investment, and the emotional strain. Make sure your relationship is strong enough to withstand what can be a very difficult process. Talk openly with your partner about expectations, timelines, and backup plans if the immigration process doesn't go as hoped. In conclusion, the Trump administration's new rules regarding marriage-based green cards represent a significant shift toward increased scrutiny and more stringent evidence requirements. These changes are already impacting thousands of couples and will continue to affect many more in the coming months and years. If you're pursuing a marriage-based green card, you need to be more prepared than ever before with extensive documentation, thorough preparation for interviews, and ideally professional legal guidance. The process has always required proving that your marriage is genuine, but the bar for what constitutes sufficient proof has been raised substantially. Success requires patience, persistence, meticulous attention to detail, and a genuine commitment to demonstrating that your marriage is based on love and mutual commitment rather than immigration benefits. Thank you so much for watching this important update on U.S. visa info. I hope this information has helped you understand the current landscape for marriage-based green cards and given you actionable strategies for navigating this challenging process. If you found this video valuable, please hit that subscribe button and turn on notifications so you never miss our updates on immigration news and visa information. Drop a comment below if you have questions or if you want to share your own experience with the marriage green card process. Your insights could help others who are going through similar situations. Share this video with anyone you know who's navigating marriage-based immigration so they can be fully informed about these new rules. Knowledge is power, and being prepared is your best defense in this complex immigration environment. Stay informed, stay strong, and I'll see you in the next